may we return at 10 to 2?
Yes, Ms. Golding, we'll do that. Thank you.
Thank you very much, Chair. Thank you, Mr. Gillies.
Thank you.
Thank you.
Good afternoon, ladies and gentlemen. Welcome back. Chair, I believe everyone is back and ready to resume.
Professor Jay, I can see your attempts to unmute, which appear to have been unsuccessful. I'm taking this by the conversation we're having that I should go ahead, and I will presume to do so. Thank you very much. Mr. Gillies, good afternoon.
Good afternoon.
Just a few further questions. We were dealing with the new Mostyn documentation just before the break. Can I ask you to look back at that documentation? It's B29 of the bundle. Danny,
yes.
Can we get up 022, please, Danny, the first paragraph, which is, it is the inquiry's view that the charity's trustees did not cooperate openly and transparently with the Commission. They did not provide accurate and complete answers to the Commission regarding the earlier allegations, and they did not report a serious incident to the Commission. Now, as I understand it, whilst the trustees did engage with the regulator at the investigatory stage, the trustees didn't engage formally following the opening of its inquiry, as I understand, upon legal advice. Have you changed your relationship with the regulator subsequent to the completion of this particular report, or taken steps to ensure that particular congregations' trustees abide by the rulings of the regulator or act transparently in respect of them subsequent to this?
Yes, we have a good relationship by and large with the Charity Commission. It's not a problem. When they write to trustees of congregations, they do engage. If it's about our child safeguarding policy, they will consult with the branch office, of course.
Okay, and if I can also check, there is an ongoing investigation into the watchtower, which I think has been ongoing for a number of years. You indicate in your first witness statement that CJW 000052 at 025 between paragraphs 92 and 99, your concerns about both the new Mostyn and the Watchtower Britain investigation. So 92 to 99 was that, identifying, if I may summarise, possibly, hopefully correctly, the concerns, which is in effect, it's been going on too long, and it seems to be going on, and there have been a number of different individuals involved, so to speak. Does this give you cause for concern as to the ability or the appropriateness of the Charity Commission to regulate or engage with child safeguarding issues?
Well, throughout our discussions with the Charity Commission, and I would say they've been amicable. Every lead investigator we've engaged with coffee and cake, and we've had a very nice discussion with them. Although we maintain the position that their inquiry is an inquiry into Watchtower, which doesn't have any concerns about child protection in the sense that it doesn't administer child protection. Nevertheless, out of good faith, we've explained our policy to them. So it has been frustrating that we've had 5 lead investigators over the period, and every time we've engaged with each one, we've tried to go over the same ground again, explaining our policy. So that's been a frustration to us. I think the comment that I make about that on paragraph 99.
Danny, if you wouldn't mind getting up paragraph 99 from the document we've just had up, please.
That's page 27.
Yes.
Okay, so halfway through the paragraph almost. It says the Charity Commission has itself stated that it can assess safeguarding policies and procedures only from a pragmatic, not expert point of view, and cannot provide detailed advice on the content or robustness of a charity's safeguarding policy. So that's our feeling, that when it comes to a religious policy, they really don't have the competence to be able to do that.
Right. And do you think they could build that competence, or do you think an alternative body should potentially be used in order to undertake auditing or any monitoring, if, for example, this inquiry were to suggest that such may be appropriate?
Or whatever the inquiry suggests, we will cooperate with any regulatory body, just the same as we've cooperated with the Charity Commission.
Okay. Obviously, the Charity Commission have indicated in their new Mostyn report that they considered that the trustees in that report didn't cooperate, and they also noted that you sought to prevent the inquiry taking place, running various legal arguments around it for a number of years. That's also correct, isn't it?
Yes, but that was to do with what we felt was a preemptive inquiry and the scope of the inquiry that we were challenging. Because we felt that the Charity Commission, is one of my recommendations or comments there, the reasons I give, that the Charity Commission, where is it now? I lost my place there. Repeat the question to me.
Sorry, it was it was around whether or not you had obviously sought various legal mechanisms, saying that there was a prematureness in the Charity Commission, and you didn't consider that it was a phishing. I think you say at paragraph 93 that you consider the statutory inquiry against Watchtower Britain may be a phishing exercise, or that's the way it had been described.
Yes, that is the paragraph I was trying to find there.
Yeah.
And it's the last sentence.
Paragraph 93. Thank you. Thank you very much, Danny. Yes.
This process appears to be manifestly unfair and a violation of the Charity Commission's own rules, which state before submitting a complaint, you must complain directly to the charity first.
Yes.
So we never had that procedure followed. In fact, in March 2014, we only had one meeting with a team of investigators who gave us a very short agenda as to what they wanted to discuss. And on the basis of that meeting, it's true there was one or two questions that we didn't know the answer to, but we promised to get back to them with the answers. But nevertheless, they launched an official inquiry at that point. So we felt it was far too premature, particularly as we had engaged with them. We hadn't received the complaints. And in fact, the Charity Commission has never disclosed the specific allegations against Watchtower.
Okay. Can I take you now to the judgment of Mrs. Justice Leven earlier this year? We looked at it yesterday with some of the witnesses, so the facts of it, I think, should be quite well known. It's behind tab B19, Chair and panel and Mr. Gillies. It's INQ Danny 0049630001. This was a case where Mrs. Justice Leven said the facts of this case raise very great concern about the safeguarding of children within the Jehovah's Witness community. That's what she says at paragraph 3. I don't think I need to break this up. Now, this was in the context of a situation where the local authority was seeking orders, or had certainly become engaged in the lives of the children, and there was a allegation of child sexual abuse by the father, made by the mother against the father. And what appears, if we go to page 5, paragraph 10 and 11, Danny, if we could get up 005 and 0010. So it was a situation whereby there was an issue about what might have been told to whom when. The Jehovah's Witnesses were asked to provide a witness statement. A witness summons was, they applied yourself, well, the particular congregation members applied to have that witness summons set aside. What then happened was that some documentation was provided at, we can have a look at 11B. So it would appear that in 2016, it was the case that the mother had reported to the elders that her daughter had told her that her father had come into the room and had kissed her. And then a matter had taken place when she was 7, which was reported in December 16, in terms of the fact that the father was sexually aroused and that there was some form of sexual activity between the 7-year-old and the father. Now, the elders plainly knew this information from December 2016, but yet those allegations were not reported to the police until July 2019, despite knowing that the alleged abuser was living in the same household, they believing that there had been various, I think, safeguards put in place by the mother. And in fact, the mother had said to the court that she hadn't reported because she felt that the elders had said they were dealing with it and that there didn't need to be the need. So it seems to me in these circumstances, this is a fairly recent case, and I think it raises 2 issues. Firstly, is the current guidance good enough in terms of making it absolutely clear that in these sorts of situations, there should be reports to the police, so that even if the parents don't wish to report, it is the congregation's duty to do so, to protect children? Do you think that your guidance, don't you think your guidance needs to be strengthened in that respect?
Yes, I absolutely agree, and that's what has happened. If you refer back to the guidelines for the service desks, you have very clearly stated in paragraph 8, which we've been through, that a report will be given to the secular authorities, the police, if there is a child at risk. So,
but the
yeah,
difference is that those guidelines are pretty much the same between 2016 and 2019.
So the difference going back to 2014, or 2016 was it?
Yes.
The difference then was that the elders accepted the reassurances of the mother that she was providing proper safeguarding in her extended family. So a report wasn't made at that time. However, our policy now is that a report will be made to the police, even if the mother or a parent refuses to do so.
Right, okay. And can I also ask, this case potentially also plays into the issue which most people find boring, but I find fascinating, of record keeping, which is, it seems clear that inadequate notes were kept by the elders in this context. Are there any guidelines that you issue as to keeping adequate notes, making sure that if there are disclosures, that those are set down fully and accurately, making sure that you record this information? Is there anything you can point me to that makes it clear what the elders' recording responsibilities are in that respect?
Yes, that's a good question with record keeping. So when elders make a report to the police, they make a record of who reported, when they reported. When there is a case that's ongoing, elders will keep their own personal notes as a memory aid. And when the case is completed, they will complete a short summary of what's taken place, and that will be kept in the congregation confidential file.
Can I also ask, the argument that was run was that there was no duty to disclose this information by the Christian Congregation of Jehovah's Witnesses on the basis that it amounted to spiritual counselling and therefore was an infringement of Article 9. Now, for the reasons that Mrs. Justice Leven sets out at some length in her judgment from paragraph 19 onwards, and I'm not going to take you through it because I know you're not a lawyer and this isn't the time or place to have these debates, but it suffice it to say, robustly rejects that argument, identifying that either it doesn't meet the criteria of spiritual counselling, or even if it does, any duty of confidentiality is plainly overridden in the case of child protection. In the light of her judgment, have you considered or thought about amending your advice to elders or to ministerial servants to automatically provide information and not require court orders in the circumstances of these sorts of cases?
Well, first of all, ministerial servants wouldn't be involved in the process. It would only be elders. And when it comes to confidential information, as you rightly say, I'm not an elder, but I do understand that there are the law respects the right of confidentiality in settings where religions hear a confession. So the dilemma that our elders have is that if they receive a confession, what do they do with that? When there's a child at risk, yes, they make a report to the authorities. When there is a criminal investigation opened and there is a request for confidential files or notes or what the elders know themselves, they will ask for that in writing. They're happy to cooperate with the police, but when it's a balance of confidential information, and again, I'm not a lawyer, this is just the way I understand it, it goes to a judge. So a production order is made. We like it when a judge evaluates what is in the file. So in other words, if a judge says, okay, I think that particular document you have there is relevant to the police investigation, then that is provided to the police. But there's other documents which may not be relevant. And it's very good when a judge makes an evaluation. We've seen cases where judges have said, okay, well, I won't make a disclosure order here, or yes, in this case, I will do so. And we feel that that respects confidentiality in the congregation, which is an important thing when someone opens up to elders and expects that what they are saying to elders is confidential.
I suppose I can completely understand in the context of a criminal investigation, you saying there needs to be a production order, or we prefer it if there's a production order, it seems to me. But if there's a situation where somebody confesses, I mean, absent the seal of the confessional, which both myself and the chair and panel are more than familiar with, having had days of evidence about the role of the seal of the confessional, your particular form of confession wouldn't meet that absolute obligation. So as you say, it's a question of balancing rights. In those circumstances, wouldn't it be better for you to say, if a confession is made, just as a psychiatrist would say the same, myself as a lawyer would have those sorts of obligations, ministers of religion, you would say, if you tell me that you have committed a serious criminal offence, I will be under an obligation to report that, even if it is said in a confidential manner. Would that not be a more appropriate stance than saying we will respect the confidentiality?
Well, I believe that is what we do, because we will override confidentiality when we believe that a child is at risk. So that is our policy. I think what we're saying here is we're going on to a different procedure, a criminal investigation, and at that point, what happens? We have to also respect an individual's right to give consent. So if the elders say to the police, yes, we'll provide you more information, but we need the consent of the individuals concerned, because it may not just be the individual who's confessed, there may be other people involved. So it can get quite complex for elders. So we try and guide them through that process.
And the guide is they need an order of the court. We're not going to do it without an order of the court.
No, when there's a child at risk, they make a report to the police and they provide whatever information they have at that point. Okay,
so, but obviously in that case it didn't happen. I'd like to have a look at the case of Clifford Whiteley, which was an individual who pleaded guilty in February of this year to 10 years imprisonment. He was a Jehovah's Witness and an elder. We have a witness statement from a DC IICSA, who was the officer in the case in the prosecution of Clifford Whiteley, behind tab A18. I'm just going to, while everybody gets that up, I'm just going to set some of the facts out. The victim came forward in February 2019. She was 21. She identified that the abuse had occurred when she was between the ages of 10 and 12. So a decade later, she came forward. In March, her sister, the victim's sister, informed DC IICSA that Mr. Whiteley was due to speak to church elders and she believed he may make admissions as part of the process of repentance. And those two elders were individuals called Rudy Thompson and David Clifford, and we have witness statements from both of them. And we then have over the page on page, Danny, would you mind getting up page 2, OHY 0099130002, paragraph 14. So he spoke, IICSA, after having been told that information, phoned the elders, and the elders said, paragraphs 13 and 14, Danny, would you like me to say the number again? OHY 0099130002. Thank you, Danny.
Sorry, okay, it's on the screen, that's okay.
Yeah, if you just like to, could you enlarge 13 and 14? So Mr. Clifford was apprehensive, a serious matter, and if it was discovered that information was being withheld, he agreed to speak to me. I subsequently he refused to speak further re Whiteley, citing his spiritual duty to maintain confidentiality. So it then turned out, if we go to paragraph 17, as the investigation progressed, I became aware that on or around the 15th of March, Whiteley had attended a meeting of elders at the Jehovah's Witness meeting hall. Could you please enlarge paragraph 17 and 18, Danny, if possible? Allegedly made an admission to them, and he was disfellowshipped, and that he was no longer a Jehovah's Witness. And paragraph 18, this information was not passed to me by the elders at the congregation, although they clearly knew, obviously there'd been previous telephone conversations. I was made aware of that through family members. And again, it then came to a situation where I think it was in October 2019, eventually the police sought a production order. In October 2019, a judge looked at the matter and determined that the information should be provided. And when the information was provided, it turned out that it was a confession that he had sexually assaulted the particular person, that he was drunk on the time, and that he admitted it, on the basis of which there was disfellowship. So what DCNSAW says is, and can we go to paragraph 33, please, Danny? There's 33 and 34, which is 004005. If I could just ask everyone to spend a couple of minutes reading that rather than me reading it.
Could we have it enlarged, please?
Yes, please. Could we? Yes, I was about to say it's illegible other than that. 33 and 34, please. I think maybe, Danny, would you mind moving 34 over a bit? Because if it's anything like my screen, you can't see the second half of 34 if you're on a full screen. Thank you, that's very helpful. So what he says is, had the church supplied this evidence sooner, it would almost certainly have led to him being charged and brought to justice much sooner. And at paragraph 34, he expressed his frustration and is difficult to understand that they could be withholding evidence. Now, we have two witness statements from Mr. Dobson and a witness statement from yourself, at which you in effect explain in these sorts of circumstances, you always require a production order, and it took the police quite some time to produce that production order. But I suppose it reinforces the point that I've made, is shouldn't there be some situations whereby the duty of confidentiality in respect of these sorts of judicial committee meetings are overridden in the case of confession in order to ensure that crime is appropriately investigated?
Well, this is not a case of child abuse at the time where a child was currently at risk. This was an adult bringing a complaint to the police, which they did the very next day that the elders heard about the matter. I think we have to look very carefully at Mr. Dobson's statement to see what the delay was. The elders were quite happy to cooperate immediately with the police. On March the 1st, DC Enzor spoke to Dobson, and he asked him a number of questions.
So sorry, Mr. Gillies. I'm just going to ask Danny if you could take that document down, please. We don't need it up. Thank you. Sorry, Mr. Gillies. Would you like us to get up Mr. Dobson's witness statement, which sets out the summary? This is CJW 000122004 behind tab A5, Chair and panel. It's sort of A51. It's his second witness statement, I think. And it's sort of paragraph 19, there's a chronology of events. Is that helpful, Mr. Gillies?
Yes, it is. So, yes, we're on paragraph 19. That's a summary, yes. So, Mr. Dobson mentioned that on March the 1st, he was contacted by DC Enzor and asked to provide information. He asked DC Enzor to put his questions in writing so that he could give it some careful consideration. He never heard any more until mid-July. So he was quite happy to cooperate in March. He just asked for it in writing. And then in mid-July, he was contacted again. But it seemed as though, sorry, I'm choosing my words because I don't want to talk about anybody that would reveal confidence, but
No,
the abuser here. So
we can name the abuser because the abuser has been convicted of a criminal offence. So that's fine, Mr. Gillies.
yeah, Mr. Whiteley then.
Yes.
So he had been the subject of judicial committee and he had been disfellowshipped from the congregation. And so they had information, you're quite correct. But now here comes the criminal investigation where the police are asking for statements. So there is a balance here of confidentiality for the reasons we discussed earlier. So they were asking simply to put it in writing, and if they had the permission of Mr. Whitley to talk to them, then that was fine. Consent was okay. Mr. Whitley refused to give his consent. So at that point, the elders were advised that they basically need to ask the police constable to get a production order. A lot of distress was caused to the young lady, and it's understandable because there was a long delay. But what was the reason for the long delay? DC Enzor puts in his statement that the elders weren't cooperating. They weren't cooperating on his terms, but they were asking for it in writing, and they were asking for the consent, and then they were asking for a production order. So as you rightly said, it took till October until the DC Enzor actually got that production order. And when that went before the judge, my understanding was that the decision was, yes, that is relevant, but I don't take confidentiality lightly, was the judge's expression.
Okay. I think we have a witness statement from PRA 42, which is, Danny, if we could just get that up quickly, who's the victim in this case, JLE 000051001. And one can see at 002, Mr. Clifford and Mr. Dobson, at paragraph 11, stayed in touch with PRA 42, and they sent messages saying to pray and that they were praying for him. And she said how upset she was because Mr. Dobson said what a good elder Mr. Whiteley had been and how he had helped the congregation. She finding her upset on the basis that this was on or around the time when he had confessed to sexually assaulting this young woman. At paragraph 19, if we could go to the next page, please, Danny, 003, she says, Mr. Whiteley's confession to the elders was the biggest single piece of evidence we needed in our pursuit of a conviction for his abuse. Without this confession, it was just my word against his in what was a historic abuse case. DC IICSA asked Mr. Whiteley for his permission to obtain the details, but he refused, knowing that the elders would not cooperate, as was their policy. And then if we go to paragraphs 20 to 22, please, Danny. And 23, once I was made aware of these developments, I asked them to meet with me to explain why they wouldn't help the police. And then they said, paragraph 21, began by sharing a passage from the Bible about slander, explaining that because they are under a particular oath, they are unable to speak to the police. Now, that's not my understanding and reading of the Watchtower article. So how could they have, if they'd been speaking to the branch office, as everybody says that they should have been, how could that information have been miscommunicated to them in such a profound manner?
Well, you have the statement there of a distressed lady, and that's understandable because she was being told that the elders were not cooperating. What it appears that she wasn't told was that the elders were cooperating. They were just simply asking the police to put the questions in writing. And if there was no consent from Mr. Whiteley, then to get a production order. Basically, that whole process could have happened in a few weeks. So it doesn't seem to me as though there was a failure of our policy there. It was more the fact that the process was drawn out. Because as I see it, the police officer seemed to delay the process in getting the consent and then the production order. So it's understandable why she would be feeling that way.
But if I can just indicate that, why would she have said about slander at paragraph 21 unless that was what the elders had told her? He wouldn't necessarily be something that you in and of yourself would know or would think about. So are you suggesting she's mistaken in believing that that's what the elders said?
I don't know what the elders said because they haven't had the chance to comment on her statement. But if you're asking about confidentiality, I will read you the verse that could be applicable in a situation like this. It's Proverbs chapter 25 and verse 9. And it simply says, but do not reveal what you were told confidentially. So these are confidential settings where elders give shepherding help to victims. They're confidential settings where they take action against someone who's to be disfellowshipped from the congregation. So there's a process that needs to go through in order to divulge confidential matters. Now, we've mentioned that if a child is at risk, then that confidentiality is overruled. But if it's a case of an adult victim, there's no child currently at risk, then the process is gone through, as we've explained.
I want to turn next to one specific aspect of JW practice, which is what happens after somebody's been disassociated, disfellowshipped, or there is an issue of bad association. And in particular, if that takes place when people have made allegations of sexual abuse. Can we please go to the witness statement of PRA 39 behind tab B40, Mr. Gillies? It's JWA Danny 00000002. I think that's 5 zeros and then a 2, although I may well have said 55 zeros. And it's page 2, paragraph 10 to 13, please. That's JWA 00002003. And this is a situation which took place in the past decade, if I put it that way. So this isn't something which happened 20 years ago, 30 years ago. This has happened at some point in the 2010s, shall we say, in the decade that's just passed. And that the perpetrator was supported in court by the elders, whereas she received no support whatsoever. And she was then shunned by her father and her children, who remained members of the Jehovah's Witnesses. Now, she says this was a direct result of my reporting to the sexual abuse to the authorities and bringing reproach on Jehovah. And it said, paragraph 10, my immediate family remain members of the Jehovah's Witnesses. I was expected to remain silent about my sexual abuse. Now, on this basis, do you accept, therefore, that there have been occasions when people are shunned if they decide to break that silence and report sexual abuse to the authorities?
Well, our policy is that we don't shun anybody for making a report of sexual abuse. I think that's very clear in my statements. What that witness said yesterday was that she'd never been disfellowshipped, she'd never disassociated herself, she basically just decided to leave. It seems to me that the statement that's being discussed here is where she's talking about the family having nothing to do with her. So that wasn't a formal decision that was made by the congregation. Who knows, we don't know what the allegation was. We don't know whether there was a family dispute about it. We just don't know. I have no idea what the situation is. But when the emotions are run very, very high on matters to do with child abuse, then of course individuals may end up not talking to each other, even family members. But this was not a formal decision that was taken by the congregation as far as I understand. But
given the fact that you do socially ostracize, I'm not going to use the term shunning, I'm going to use the term ostracization. Given that you do, in effect, provide an official sanction for that in various circumstances, including where Jehovah's name has been brought into disrepute, which some people might consider to be the case if you reported on your Jehovah's Witness brother, as we discussed earlier. Do you not think the fact that there is the imprimatur of social ostracization in those circumstances make it more likely that these sorts of desperately unhappy family breakdowns will take place?
Well, Jehovah's Witnesses know all about ostracism because there's thousands of them that have been ostracized by their families when they decided to leave the religion of their birth, and friends have rejected them, so we know what that means. But having said that, we do not, I can only repeat that we do not ostracize or disfellowship anybody for being a victim of child abuse. That's all I can say on this subject, really.
So we also have another example, which is a statement from a mother, PRH 14, which is behind tab 42. Danny, if we could get up JWA 0000110003. There was an issue there about the fact that after the abuse had been reported and that they were told by an elder to leave it in Jehovah's hands. This is paragraph 14. Danny, could we go to the previous page? I do apologise, 002. Paragraph 14. To stop any further contact with this person, the elder told me to leave it in Jehovah's hands and that he would handle it. Nothing will be uncovered and it can be uncovered by Jehovah. And as I understand it, there was then, one of the elders then interviewed her son without the permission of her mother about the matter, before a more senior elder in fact came and encouraged them to report it to the police. If one looks at paragraph 27, Danny, she says that after she went to the police, both herself and her child has been shunned from the congregation or made no longer welcome. The elder cut the child off and said it was best that the child no longer attend the Kingdom Hall. The child was being targeted, although he was a child and victim of sexual abuse. Now, in fact, what the elder may have been doing, and we simply don't know because we don't have his evidence, and you know, I accept that, was saying maybe it would be a good idea if you went to another congregation, because that individual being repentant was potentially repentant and therefore would still be in the congregation. And she says that, in effect, the adult was supported by the congregation and her child were not. And they saying they were essentially ostracized despite the fact that the other person was the guilty party and they were the innocent party. So again, do you think that this is something which only happens very occasionally? Or do you think that in fact this may well be something which is more widespread And therefore, do you think that you should issue better guidelines than you do to try and avoid this very unfortunate situation occurring?
Well, we believe that our policy now addresses those issues. Very difficult to comment on a scenario like that, where, as you say, we don't know how the case was handled, we don't know the circumstances, we don't know who was doing the alleged shunning on that particular occasion. It's very difficult to sort of give a guidance on it. I don't know how long ago even that case was. But the fact is that we do everything we can to ensure that relationships are restored. We work very hard in our congregations to create a peaceful atmosphere. We regularly review scriptures in the Bible that speak about how to resolve differences with family members and so forth. So we will try to help people where there is those kind of situations. After all, we don't want to see people leave our religion. We want them to come back. We want them to be associating with our religion.
But can I ask, you accept, however, that if people, once they've been abused, wish to dissociate themselves from the faith as a result of their abuse, they feel that they've lost trust and respect with the family which they've grown up with. One can well understand why that might be the case. Do you think that the then approach of exercising your religious conscience and maybe not continuing to be friends with that person because they've disassociated themselves can have a particularly traumatic effect on those who are victims of child sexual abuse?
I think you've got to look at the difference between somebody who leaves and, as we would say, going inactive, and somebody who disassociates themselves.
Yes.
As we even heard yesterday, we heard from individuals who hadn't actually been formally disfellowshipped or disassociated themselves, but they'd gone inactive. So there's a category of individual where they haven't made a definite decision that they're not wanting to be one of Jehovah's Witnesses. Perhaps they've just drifted away. We reach out to those individuals periodically and ask them if they'd like to reassociate and come back and try to help them. But you're talking about disassociation where somebody informs the congregation, usually in writing, I repudiate the faith. I do not wish to be known as one of Jehovah's Witnesses. So that's a very formal disassociation from the congregation, and we respect that decision. But naturally, it changes the relationship of the congregation to that individual. We don't necessarily know why the individual has taken that course of action, what it is that their grievance is. Elders, usually before they accept a disassociation, will try and say, can we help you? We view people who leave our religion like the illustration in the Bible of the lost sheep. The 100 sheep and 99, he leaves the 99 behind and goes after and searches for the lost one. That's what our elders try to do in those situations.
And do you think that the threat of social ostracism, if people come forward and then end up leaving, or because somebody might be considered to be bad association, do you think that creates a disincentive to victims to come forward in the Jehovah's Witness faith? It's a barrier to reporting, to effective reporting.
There is no sanctions against anybody who reports child abuse to the authorities or to the congregation.
Can I just double check a few things about your child protection, the policies and practices you have? I think I did ask you this question yesterday, but I just wanted to check in my own mind. You don't conduct, there are no external audits conducted of your child protection policies and practices, are there?
That's correct.
And is there any reason for that?
Because our policies are very weighted with how to deal with things within the congregation. If somebody came out from the outside and conducted an audit, okay, one thing if they conducted an audit to see if we were practicing, applying our cases in harmony with the law. But if they were coming in and saying, okay, why didn't you disfellowship this person? Why did you judge them to be repentant? Should you have disfellowshipped them? That's not something an external auditor could really do, because they would have to understand the process that we go through within the congregation. to take disciplinary actions.
And are there any arrangements you have internally to make sure that local congregations are following the relevant policies and procedures?
Yes, you asked the question yesterday about circuit overseers. So when circuit overseers visit the congregations, they give reminders to the bodies of elders. They make sure that the elders are following the policies and procedures.
And have any elders, for example, as a result of some of the cases we've looked at just now, have any elders ever been disfellowshipped or removed or disciplined as a result of a failure to follow the safeguarding policy? Would a failure to follow the safeguarding policy be considered to be an offence which could be the subject of spiritual discipline?
If elders do not follow our policy, yes, it could result in them being removed as elders.
Do you know if that's happened in any of these cases?
I can't think of one, no.
I'd like to deal next with the total number of allegations of child sexual abuse that you've had over the past 10 years. And this comes, can we go back to your witness statement, if we may? CJW 0000522023. And paragraph 81 onwards. So there have been 4 civil claims, 3 have settled, and then there in fact has been another claim subsequent to that, but that involved 2 adults, the BRXB and the Watchtower claim. And you say that there have been, past 25 years, the branch office was contacted by elders who reported child sexual abuse concerning 25 elders, 32 ministerial servants and 10 persons. The following chart sets out how the allegations were dealt with by secular authorities and the congregation. So I can see here only 37 of the allegations were reported to the authorities. Why weren't all of them reported to the authorities? Do you know?
They were allegations, so I don't know why they weren't reported. Are we talking about adults here who were victims and who had no desire to go to the authorities? I don't know the answer as to why that is the case. All I can say is that these are the statistics. And these are allegations, so not anything that's been confirmed, but so in the absence of the congregation verifying that the allegation is true, the individuals concerned, as we've discussed in our policy, are free to go to the police and make an allegation themselves, make a report. So,
and we can see of those, there have been 13 criminal convictions in the past 10 years, and 25 people were subject to an ecclesiastical judicial committee. Now, what I suppose you can't tell me is how many of those who were criminally convicted were also the subject of an ecclesiastical judicial committee, because that will depend upon whether or not the 2-witness rule was or wasn't satisfied, I'm assuming.
You're right, I can't answer the question.
No, that's absolutely fine. We also have an individual who's provided us at tab B39. That's in bundle number 2, Mr. Gillies. We have in B39 a list. Danny, if you wouldn't mind getting up JWS 00005001, which is 49 people who have been convicted of criminal offending on the basis of news reports since approximately 1999. So we've got, in fact, 51. In fact, we've got 59 in total from 001 through to 003, of which the last few are redacted. But one can see that there are 51 unredacted convictions which date from the 1990s onwards. Is there anything you'd like to say about that? Do you consider that that's about the right, I mean, it's difficult to know, but do you consider that that's a too high number, or in fact is less than you would have expected in terms of convictions?
You're just talking about the convictions,
Yeah.
because that's convictions, a few elders and ministerial servants there,
Yeah.
but other individuals who are what you would call lay members.
Yes.
That's being discussed there. So we have, as I mentioned, 130,000 witnesses in the country now. So, you know, that's a list that goes back many years in many cases. There could even be individuals in that list who had some kind of association but left the congregation. It's very difficult for me to comment with any degree of certainty.
Okay. I would like to ask you now about recommendations, and particularly in respect of recommendations for improving child protection. The first point I wanted to ask you about is the role of women. Now, we've heard from a number of witnesses in our evidence in this particular strand of the investigation and others, how useful women find it to report to and speak to other women rather than men when it comes to child sexual abuse. Now, I understand that from a spiritual perspective, elders cannot be women, and I'm not seeking to ask you to change that, but can you envisage women performing some specific role, whether that's a role of pastoral support and counselling, or that they could be given a role in investigation and support for victims of sexual abuse?
Well, if I could refer you again to our May 2019 Watchtower, this shows how elders, yes, how women can be of great assistance in the congregation to bring comfort and support to victims of child abuse, absolutely. If you turn to page 19 of that document, tab at 23, or rather 2 pages there, 18 and 19. Sorry, 18 and 20. Article 20 in our May edition of the Watchtower.
Okay. But, I mean, it is true to say that women don't perform any secular positions. They don't have any secular positions of authority in the context of your congregation, leaving aside what the spiritual issues are. So you don't have any women safeguarding officers or women child protection officers or women counsellors?
No, but we have the women who support the young women. That's what's being conveyed here. And even in the context of talking to the elders on page 20, you notice there that when they're talking, when a victim is talking to the elders, she might be expressing what's happened in that picture, but she has a woman confidant with her to support her as she's giving evidence to the elders, because the elders have the responsibility to institute an ecclesiastical process or to ensure that a proper report is made. And then in another context, the victim there is still with the support sister, as we would say, when the elders are providing comments from the Bible and also when they're praying with her. Now, after that takes place, it could be that the elders say to that older woman, could you provide some ongoing support? She needs a lot of assistance to get over this or to learn how to live with it. And that's what you see pictured on the previous page, page 18. You see that older woman being part of the process of giving comfort. So there is a valuable input that our women give. They're very experienced. They know, they understand the issues. As you say, they will understand the feelings better than a man would.
Do you think that encouraging women to play a more central role might avoid what we see at tab B49, which is PRX 00002001 through to 004, which is a list of at least 19 individuals whom this particular person says the victims were dissuaded from reporting to the police and they were urged by elders not to do so. Do you think if women had more of a role, there would be less of this?
Well, that seems to be the same list as you showed me earlier.
Yeah.
But our policy is that Sorry, did you just say to me just now that they were dissuaded to make a report to the authorities?
To the authorities, yes.
So my understanding is that they were reported to the authorities. I don't know all the circumstances though, because I've only seen the list that you've handed me, and I don't know the background. One or two names there look familiar, but I can't really comment on whether they were dissuaded or otherwise.
Would you object if there were any sort of mandatory guidelines or standards involving the requirement for some form of professional safeguarding training for elders?
We'd gladly look at any training materials that was presented to us and see how they apply to in our environment.
Right. And do you have any form of redress scheme already in place for those who've been subject to child sexual abuse within the congregation, either in the UK or in other countries?
Well, we'll always care for individuals in a fair, loving and compassionate manner. And if we're talking about institutional abuse, then naturally we feel a responsibility. So we prefer to look at matters on a case-by-case basis.
Now, as I understand it, following the Australian Royal Commission, they set up a national redress scheme. And as I understand it, the Christian Congregation of Jehovah's Witnesses have decided not to join that scheme on the basis that they don't have the institutional settings that the redress scheme is designed to cover. Do you therefore believe that if, for example, the panel were in their final report to suggest that there should be some form of redress scheme for religious organisations and bodies, that you would take the same approach here in the UK?
We never said that we were against redress schemes as such. What we said was that the Australian one didn't apply to us.
And in the interests of transparency, do you think that your body and all religious bodies and other voluntary organisations should be required to publish annually data on the number of allegations, the status of those allegations, and the outcome of those allegations, and possibly if compensation has been paid, the amount of money that's been paid out?
Well, that's a big question. I'd have to sit down. I think we'd have to sit down and think about the answer to that question. In principle, we act on the law of love. We act according to justice. So if there's been some injustice, then naturally we would want to make sure that a person is dealt with in a fair way.
Okay. So you would have to think about it, but you wouldn't necessarily object to it on principle?
On principle, no.
And if there were to be auditing by an external body of your safeguarding practices and procedures, then, sorry, I've just been distracted by Mr. Tazib's just sent me a message, so there's something I need to check with you. If there would need to be any auditing by an external body, would you object to it in principle?
Well, again, we'd have to ask the question, what do you have in mind when you talk about auditing?
Well, I think it would be somebody looking over practices and policies, making sure that A, they were adequate to protect young people, B, that they required minimum levels of training, and C, that the policies actually were put in practice, were used in practice, by maybe examining cases to see what people had done or hadn't done in various instances.
Well, what we're talking about today is a worldwide policy of Jehovah's Witnesses, so we would have to look at the policy in that context. But in principle, for all the questions you're asking, you see, we are motivated by what we call the law of the Christ. So the law of the Christ is how Jesus taught and how he sympathized with people and how he showed them compassion and pity. So any kind of arrangement that makes our policy more robust and harmony with the law of the Christ is fine.
Thank you. Can I just clarify with you, slightly earlier when answering a question you said you are not an elder. Of course you are an elder. I think what you meant to say was you are not a lawyer. We've been asked to clarify this, so that's my final question to you.
Okay, I'm glad you clarified that point. Thank you very much indeed.
Thank you very much. Now, if you wait there, the chair and panel may have some questions for you.
Thank you, Ms. Scolding. I have no questions, but I will check with my colleagues whether they do. Ms. Sharpling.
Yes, just the one, if I may, Chair. Thank you, Mr. Gillies. Can I ask you whether your policies that you've described over the last 2 days contain anything about the provision of an apology where there's been institutional fault?
Our policies don't contain that, no.
And is something such as an apology ever given on a case-by-case basis? So you've talked a lot about dealing with things on a case-by-case basis. Is apology ever provided in those circumstances?
We would be very happy to look at the facts and see if an apology is necessary or called for.
Thank you.
Mr. Frank.
Yes, please. First of all, is it right that you were appointed to your current post in 2018?
Yes.
And the post is Director of the Office of Public Information of the World Headquarters of Jehovah's Witnesses?
Yes.
And that's based in New York, I think.
Yes.
Before you, who was your predecessor in that post?
Mr. David Simonian.
Do you also have a post of the records manager overseer based in your office or elsewhere?
That's not my position, no.
Do you know of someone who holds that position?
Are you talking about the World Headquarters?
Whether it's the World Headquarters or anyone else, do you know of anyone who occupies the post of records manager overseer?
Well, we have records management guidelines, and each department will oversee its records management.
Do you know a person called Sean Bartlett as a records management overseer?
Yes, I do.
Did he come to give a seminar to elders in England in 2017?
Yes, he did.
Did you attend that?
I think I did. I can't recall it specifically.
You might recall it if you remember the content of the seminar. Can you remember what the purpose of the seminar was?
To help us to make sure that our record keeping was up to date with legislation, and that we weren't keeping unnecessary documents.
Not keeping unnecessary documents. Do you mean that he advised you to get rid of some documents?
Well, of course, at that time, and even now, we have data protection matters, so we have to make sure that documents adhere to data protection issues. So yes, he would have advised along those lines.
My next question is, do you have a data retention policy that you have published?
We have a data retention policy. Have we published it? I don't know.
In any event, you were at the seminar in 2017 where Sean Bartlett, among other things, advised you how to keep and how to get rid of documents.
Yes.
Did he, in the course of that seminar, tell you that the reason for getting rid of documents was because Satan was coming after you? Satan in the form of the legal process.
Okay. His comments, as I say, were directed with regard to data protection issues, as I recall. I don't remember exactly what he said on the subject. No, I don't remember any comments about Satan particularly.
You know whether there is a record anywhere of that seminar, of what was said?
I'd have to find out for you.
Do that and please let us know. Thank you very much.
Thank you, Mr. Frank. Sir Malcolm.
No, thank you, Chair.
Thank you. These are all the questions we have. Thank you very much, Mr. Gillies.